Update, where's the baby? Brief recap. Dad has sole custody. Mom doesn't want visitation. Order signed by the judge. Despite all that, the judge gives mom sole custody and has the exchange happen in open court. It's a long story. Go back and watch the 2 4-part series.
But in the meantime, the child should stay with my client.
Let mom have the child right now. Okay.
Crazy.
Thank you.
Can I get an order that if you're denying my motion, I don't appeal the order to.
Counsel for Dad files a writ of prohibition with the Court of Appeals and a motion for emergency relief. A writ of prohibition is asking the Court of Appeals to issue an order to say, no, judge, you can't do that. And he wins. But this is the order on the emergency relief to return the child. Notice the judge is a named party. It is Dad versus the judge, and mom is a real party in interest. You can tell by reading the order that the Court of Appeals is flabbergasted by the trial court's decision. During this hearing, responded, that means the judge, asked mom why she gave up custody and contact with the child. Mom testified she didn't have a job, lost her apartment, was living with her parents, and she had an autistic son with behavior issues that caused concern for her having contact with the baby. The Court of Appeals notes that there was no testimony that the child was in danger and that counsel for Dad repeatedly objected to the hearing. In order to get emergency relief, the legal standard was that Dad has to show that irreparable injury could happen, and he wins on this. The Court of Appeals states that the judge removed the child from Dad's care and custody based solely on bare allegations that the dad was acting erratically. The judge made no findings that the child was in danger and made no findings that this was in the child's best interest. In fact, the trial judge hasn't even issued an order. Court of Appeals grants the emergency motion and says that mom shall return the child by Wednesday, November 6th at noon. Does she? Follow for part 2.